Welcome to Off the Clock, the webcast of employment attorneys at Miller Johnson, where we discuss what is happening in the HR world and provide practical insight and advice. We are your co-hosts, Rebecca Strauss and Sarah Willey, two employment lawyers who spend their days guiding employers through all of the challenges that workplaces offer.
Welcome to Off the Clock. I'm Rebecca Strauss. I'm here with my colleague, Sarah Willey. We're here today to discuss all that we've been hearing about Twitter on the news. We're sure you have too. Who only knows what's happened since we've taped this episode, but we're going to break down all the various twists and turns we've been listening about and explain what we as a business community can learn about what's happening there. You know, I've been having a lot of fun.
I know you have. Yes.
Following all the updates on Twitter, thinking about our HR clients vicariously, wondering what they're thinking as they're hearing about
That's exactly right.
all of this. So should we just dig in and kind of go through it chronologically, right?
Yeah, I think that's a great idea.
What we first heard reported, what we next heard reported, and what folks can learn from that.
Yeah, right, because as you and I have discussed, there's some takeaways here.
Yeah.
Both for us and I think for our listeners, and that's the fun part. So you start at the beginning because you really have been having maybe a little too much fun keeping track.
Well, I do have fun with silly things.
Yes.
But I do really find it fascinating what's happening. So let's start at the beginning.
Right.
As most people know, Elon Musk bought Twitter, that there were around 7,500 employees. There are rumors reported that he told private investors as part of the deal he was going to plan on cutting the workforce by around 75%.
Right.
So it turns out whatever else you think of Elon Musk, he may be a man of his word. Right?
That's exactly right.
But that rumor was not widely reported, at least I hadn't heard it. So what happened the week after the sale seemed to take a lot of people by surprise. So the week after the sale, it was reported that around half, around 3,700 Twitter employees received notice or not that they had been involuntarily laid off effective immediately.
Right.
And by not, I mean some people reported just not being able to log onto their computers and those sorts of things.
Okay.
Without anyone telling them.
Right.
Why?
Right. So those of us who have had a moment where their badge doesn't work or their password doesn't work and they think to themselves, have I lost my job? Right. That really apparently can happen.
Yeah.
Can happen in the workforce. Okay.
And in fact, it did, and some ridiculous stories have started coming out from Twitter employees saying they didn't know if their supervisor was let go or not, and it turned out they were, and they had no idea who to report to or who to turn their work into.
Okay.
So it was really, obviously, most of us heard about that on the news because it was just so shocking to have half of a workforce laid off all at one moment. So what can we take from that? No surprise, some lawyers immediately got involved, and filed a lawsuit. In California, a class action lawsuit alleging that Twitter violated something called the WARN Act.
Right.
WARN.
Right.
Because we don't want to put people to sleep this morning. We're not going to go through all the ins and outs of the WARN Act. But what people need to know is that when there's a mass layoff, a significant number of people being laid off at the same time, the exact number depends on the size of the organization. We won't go through all the numbers with you, but when you're doing a significant reduction in force, oftentimes this federal law called the WARN Act comes into play, and it requires certain notices to be sent.
Sure, right.
In this situation, plaintiffs are alleging they required 60 days notice.
Which they didn't get, meaning then they would be owed 60 days of employment, of pay.
Correct.
Right? Because they were immediately let go. And that, Rebecca, is something that I would have expected the HR leader at Twitter to know, and I'm sure he or she did know that, which just leads me to assume that that person may have also been part of it, right?
And we don't know.
And as the story continues, I think our listeners will agree that maybe it's possible that a significant portion of the HR department was impacted, right, by the reductions
That is-
at Twitter's. We don't know.
We don't know.
We don't know, but
It is also
we
possible.
will let everyone draw their own conclusions.
It's also possible, as we see this roll out and everything else roll out that we're going to discuss, that perhaps HR, shall we say politely, was not leading the discussions
Right.
and how to manage the reductions in the workforce.
And maybe legal risk was not an important consideration.
They were not.
in any of
They were
this.
not the drivers of the decisions.
Okay,
Let's
got
say
it.
it could have been oversight. It could be intentional too, right? There, as you
Okay.
and I have discussed many times over the years with each other and with clients, there are times when organizations have to balance legal risk, right, with other
Sure.
concerns and make the best decision as a whole for
Okay,
the company. So
right.
we don't know whether it was an oversight, whether it was an intentional decision. Regardless, lawyers got excited. Go figure. In California, filed a class action in California alleging that Twitter violated the WARN Act. How did Twitter respond? And I think this is going to be an interesting takeaway for folks listening.
Okay.
Twitter responded with a motion to dismiss, saying that all of our employees sign what's called a mandatory arbitration clause
Oh, interesting.
that includes a waiver of their right to assert class action claims.
Okay.
So that's a mouthful. Let's talk about what our listeners can learn from that. When I say mandatory
Sure.
arbitration claim, what is Twitter talking about? So a lot of organizations, and in my experience, typically more common as the organizations get larger,
Yeah, for sure.
like to include or mandatory arbitration agreements with their employees, and in those agreements, employees waive their right to assert claims in court.
In court.
In
though.
court.
They still can
They can't
have a
sue
claim.
you in court,
Okay.
but they can assert their claims in a private arbitration.
Got it. Okay.
And in a private arbitration, there's one arbitrator or maybe a panel that tries a case just
Got
like
it.
it would be in court, except it's private, and many large corporations prefer that
Got it.
structure over a public court case.
So in this case, even assuming they signed an arbitration provision, all of these individual employees still potentially have a claim. They may
Yes.
not be able to bring it as a group with others, as a class action, as you've said, and they may not be able to bring it in court, but that arbitration agreement doesn't completely absolve Twitter of
Right.
potential liability under the WARN Act if they didn't provide the 60 days notice. Okay.
Arbitration agreements with employees to be enforceable have to be written in a certain way, have to
Yeah,
include
yeah,
certain
right.
notices, sometimes fonts, et cetera. In California, there's a whole bunch of extra stuff in
Yes.
particular. So this is the sort of thing, it's great to think about when you're doing handbook reviews, or if you're an organization that does employment agreements with your employees. It's something to think about and talk to leadership about. Do we want to
Absolutely.
include a mandatory arbitration agreement with our employees or not? And if you do, that's really something legal counsel should be involved
Absolutely.
in
Yep.
drafting, because you don't want to go through all that thought process and all that work just to have the agreement
Be in the wrong font.
not be
Not be enforceable because you
Right.
had no idea.
Exactly. So
Great-
that's a
great
very
point.
helpful takeaway from this
Okay.
Twitter process
Right.
for everybody
Okay.
listening. And in general, the rule of thumb, although it doesn't always hold true in my conversations with clients, frankly, but the rule of thumb nationally is that arbitration is better for employers and courts are better for the employees.
Mm-hmm.
So that's just the worldview, right, that many organizations, particularly larger organizations, have. So mass chaos, as half of the organization
Is gone.
is no more.
Yes.
I just read something this morning about that, by the way. So our HR folks listening, their heads are probably spinning, thinking, "How do you lay off 3,700 people at that 50% of your workforce
Yeah.
at the same time?" So apparently, many people were laid off accidentally, and then turned out Twitter needed
That's
them.
a first for me. I've never heard of somebody having been accidentally laid off. I mean,
Right?
I understand in this context why, but okay.
So, so we don't know if this is true, but I read this morning that Twitter HR has created a new category, hiring status, for accidental termination rehire. Because so many people were laid off, and then Twitter said, "Oops, actually, we didn't
Right.
mean you."
listeners, I hope none of you ever have to create that category, right?
We hope none of you lay off 50% of your workforce
Yes,
at the same time
exactly.
either.
Okay.
All right. So now fast forward a week or two, and Twitter wants more employees to leave, essentially. They're looking to make deeper cuts in the workforce. And they achieve that by getting somewhere between 1,000 and 2,000 people to voluntarily resign.
Wow. Okay.
So
Tell me about this voluntary
How did
resignation, Rebecca,
how
right?
did they do it? All right, I love this. So Elon Musk sends an email to all remaining employees.
Okay.
And it's been referred to as the fork in the road email, where Elon Musk explains to employees essentially, we're at a fork in the road. Staying means, under this new Twitter that I am running, that we are going to have, and this is the quote I have read, extremely hardcore work culture.
Okay.
So staying means you're going to be working in an extremely hardcore work culture. If that does not sound appealing to you, you may resign. And he sent this out on a Wednesday morning. He said, if you don't respond by 5 o'clock on Thursday, we will assume you have voluntarily
Right.
resigned.
Okay. So you have 24 hours to evaluate your own hardcoreness.
Right. Am I hardcore or not? And let's not laugh at that question, because that is the exact question employees were asked to answer. There was a click through. So at the bottom of that, there was the option to click through, yes, I'm hardcore. That's how you kept your job.
And if they didn't click,
And
then
if you
what?
didn't click, then you had voluntarily resigned.
Oh, okay.
Okay, with 2 days.
That's a
notice.
generous use of the word voluntary, but okay.
Well, that
Well-
opens up a whole nother issue about how HR departments
Got it.
designate or characterize departures.
Yeah.
And we won't spend a lot of time talking about that.
Okay.
But as you know, in our world, it's the facts that matter. You can call it or name it whatever you want.
Right.
Right.
Exactly. Okay. So we can laugh about. I mean, we can laugh about the actual execution of in the word, in the verbiage, hardcore, etc. But I have to say this: I respect the honesty there.
Me too.
Right.
Yes, we were just talking about this.
Right.
If that's what it's going to be, if that's going to be the culture. Now, lots of our listeners and watchers might say, well, that's a horrible work culture. That's up to the business to decide, right? If you want that extremely hardcore work culture or not, if that's going to work for you. But if that is the direction the business is taking, and that is going to be the culture, and he said, hard work, long hours, high expectations, no exceptions, why not just tell people?
Right. And I will add this. As we understand it, it was an email that went to all remaining employees, right? So we're not talking about picking or choosing or potential discrimination concerns or seeking to get rid of certain people, right? This is an email that was very honest about what was going to be expected. And I think there is a nugget of takeaway for our listeners.
Well, it's
Right.
an interesting strategy. We'll have to see how it plays out. Elon Musk was quoted as saying, the best will stay, right? This was a strategy to get the best
Right.
to stay. But I'm not sure if that's true. And we'll just have to wait to see if it plays out. There are people who might be staying, even though they clicked, yes, I'm hardcore, but maybe they need the job.
Right.
Maybe their skills are
Right.
frankly outdated, and they know it would be hard out there in the market trying to get a new job. Maybe they have visas.
They're biding their
They're
time.
here on a work visa. And not having a job means leaving the country.
Yeah.
And that hanging over their head means, well, whether I'm hardcore or not, I'm going to tell Elon Musk I'm hardcore,
Yeah.
right? And keep my job because I want to stay in this country. So there
Okay.
may be reasons why, right? Some people might have clicked, yes, I'm hardcore, right? Even if they aren't the hardcore personalities that Elon Musk was trying to get to stay.
Yeah, so we'll
Time
see.
will tell,
We'll see.
right?
But
Time will tell.
but at the very least, they understand the expectations. And if they really aren't hardcore, they shouldn't be surprised when it doesn't work out for them, perhaps at Twitter long term.
I am sure whoever clicked, yes, I'm hardcore, and is still there because there was another wave, which I'm going to tell you about. But if they clicked, yes, I'm hardcore, and they remain employed, I'm sure they are bracing themselves.
Yeah.
For long hours and hard work,
Yeah,
just
right.
like Mr. Musk said.
Right.
They should.
Yeah.
All right, so they were offered severance packages. They said, if you resign or just don't respond, By the way, I sure hope people were checking their emails
Yeah.
that day.
What if you just didn't get it? What if you were on
Am I
vacation?
the only one that's
but
missed an email one day? I sure hope that wasn't the one. But there was severance time. So if you choose not to stay, Twitter offered a 3-month severance package to everyone. The first 2 months, you just stay on the payroll, essentially, just not work. So pay, benefits, nothing changes. If you signed an agreement that Twitter forwarded to you, a severance agreement, which includes, I am sure, although I have not seen it, a full release of claims, and you turn that back in within that 2-month period, then you get a 1-month lump sum at the end of that.
Interesting.
2-month period.
So with this second wave, they did comply with the WARN Act.
It looks like they did.
They did. So their listeners, there was a takeaway there, right? They might have been looking backward and thinking, oops, we should have complied with the WARN Act in that first wave. Okay.
Another thing they may have been thinking about, Sarah, is something a lot of our clients aren't aware of, is that when we're doing a reduction in force, which, by the way, under the law I'm about to talk to you about, means anytime more than one person is likely. It doesn't have to be a mass layoff, right? Anytime it's more than one. In other words, 2. You're laying off 2 people at the same time. There's an additional waiting period required for employees over 40 for that release to be fully effective, particularly for age discrimination claims. There's a 45-day waiting period. So it's very typical for organizations when structuring these severance agreements to say you have, just to everyone, whether you're 49, you have 45 days.
So if they were looking to get a full release of claims, then they were required to give those folks 45 days to think about whether they wanted to sign that additional release agreement. Okay.
And that's a federal law, so that's something all of our listeners and watchers should be aware of. Another little takeaway.
Okay, and let me just say, as you know, as part of that same law, you're also supposed to provide an attachment with all sorts of information about others, essentially others impacted by this decision. That attachment must have been a book, right?
And we don't know if that was provided or not.
Who knows? Maybe it wasn't provided.
Yes. So this is, employers tend to really hate this aspect of the reduction in force severance agreements. But yes, you are supposed to attach a list of everyone else in the decisional unit, everyone.
Eligible.
Not their names, but their positions and ages, and then highlighted or asterisked or somehow identified who was selected.
And who wasn't.
For availability for the layoff. Yes,
Okay,
that
got
would
it.
be a book. Yes, to your point. And when we help our clients prepare these agreements, ours always say at the top, federal law requires us to give this to you. Because otherwise everyone's like, why are you giving me this list? This makes no sense. Okay, so that got rid of another 1,000 to 2,000 people who, quote unquote, voluntarily resigned. Again, up to you, how you actually characterize that.
Okay.
And then the Wednesday night before Thanksgiving.
Oh, great timing.
Literally in the
Excellent.
night from what we heard reported. And this category would be involuntary terminations.
Okay.
So we had layoffs, we had voluntary resignations, and now we have involuntary terminations for performance reasons.
Oh, not hardcore. They've already been identified as not hardcore.
Apparently it doesn't take long.
For some. Okay.
What happened with the engineers and some other technical folks at Twitter when Elon Musk came in is they were required at the end of every work week to produce a report. And the way I heard it reported was to send it to Elon Musk. But they're supposed to send at the end of every week what they did, that week, what their plans were, what they were going to accomplish in the next week or so, and send in the copies of code that they wrote. So for non-technical listeners, software engineers, programmers are literally write type code. So, and it is, lines and lines and lines, and it is a clue as to how much you produce. It's a measure of productivity. It's also, someone can review it for how good it is, right? Mm-hmm. So because the week before Thanksgiving was a short week, apparently they still got Thursday and Friday off. Okay, so not that hardcore.
They're not that hardcore.
Give me a break. But anyway, so Wednesday night, again, from what's been reported, somewhere in the dozens, multiples of 12, people were let go either because they did not turn in the reports or the code was deemed, unacceptable.
Did they get anything?
I believe
If
they
you know.
got, I think I heard they got 30 days.
30 days, okay.
Of severance. So that, what can that teach us? What can we think about and
Yeah.
work through based on that example? I never like a middle of the night termination.
No.
But let's think about, how do we look at employee productivity? How do we measure and evaluate employee productivity? Particularly
For remote,
for
right?
remote workers.
Yeah.
That's certainly been something a lot of our clients have been struggling with since COVID, and now that everyone pretty much has some sort of hybrid workforce, right? Some people are working from home at least part of the time. Technology has helped fill the gaps. It's been very controversial, right? There's technology that measures how many keystrokes, right? And if there's no keystrokes within a certain time period, right, we will assume you're not working. There's some organizations that have cameras, right? And if the camera doesn't show you in front of your computer for a certain amount of time, it will assume you're not working.
Okay.
So that's one way organizations
Are trying to get their arms around this.
trying to get their arms around. Are you
Right.
working or not? We don't know. When you were in the office, we knew if you were sitting there. Now we just don't know.
That's the first thing that came to my mind, which is that when you were describing this weekly report, I thought to myself, I do have clients, a lot of them to whom I've talked to about those concerns. This person is working remotely and I can't figure out if he or she is actually working because their work product is not easily quantifiable, right? And I don't know how to measure their job performance, for example. And so that I do think there is opportunity for a takeaway there.
This is one
With
idea.
the report, what have you been doing? Can you summarize what you have been doing all week, or summarize what you did today in the 8, 9, 10 hours that we paid you to work?
It's not a bad idea.
It's not a bad idea.
You don't want to
No.
make it onerous, because you don't want someone to spend 8 hours of their work week, right, preparing such report.
Yeah.
So it's a balance. It's a balance, but it is, you and I work that way. Of course, lawyers and law firms, right, we record everything we do.
Right.
All day long. So we're certainly comfortable with that system. It's not off-putting to us. It may be to some organizations and cultures, but it's worth thinking about.
We're thinking about it. It's an idea that maybe we could shine up a little bit right? And use in a way that's much more productive and reflects a more positive culture probably than the way it was presented in this case.
I have seen those requirements implemented when there is, and this is even pre-COVID and pre-remote work, but where there is a suspicion that someone is not working enough or hard enough.
Yeah.
Right? They're on a performance improvement plan, something
Sure.
like that. And part of that plan includes that type of reporting. So I have seen it in that context, but what if we just did it for everyone instead of just those that we were concerned about?
It's perhaps harder to know what somebody is doing when they're working remotely, but also somebody can be at work in their office and there can be the same concern. I'll just say that.
Yes, I don't think anyone's going to argue with
Yeah,
us on that.
right. Okay.
Let's move on to the final point that I found very interesting about Elon Musk's takeover of Twitter. He sent out a notice early on informing all employees that in-person work would be required. He then backtracked a smidge and said that they would consider exceptions if a supervisor said this person's work quality is high and that, yes, they can maintain that high work quality remotely. And here's what I find really interesting, Sarah. He said that any manager who lies about that, probably didn't use the word lie, this is not a quote, but is not completely honest and forthcoming about the quality of the employee that they supervise, about the quality of that work, the manager or supervisor will be fired.
Wow. Okay.
Right? And so when we talked about that, we were thinking, we've seen lots of performance evaluations over the years, right?
Right.
That, let's just say, could be better, where everyone gets a 5 on everything, right, across the board. I personally have not seen managers or supervisors evaluated on how well they evaluate those under them. Have you?
Occasionally, but not often. You are exactly right. That is an important part of their job. One of their job requirements is to if you're a leader, right, it's to lead. It's to provide honest and accurate feedback to the people that you're leading, both on a day-to-day basis, by the way, and on those job performance reviews. So
Yes, that would be best practice.
in the moment, right, that a leader might come to HR, and we're going to have a lot of listeners to whom this feels like a familiar. They're perhaps going to chuckle, right? A leader comes to HR and says, Sarah's job performance is abysmal. We need to let her go. And HR pulls out the performance reviews, and they all say that Sarah is minimally good and often excellent, right?
Right. Exactly.
That is certainly, in my world, that's been a moment of frustration for HR.
And for the supervisor.
They're not happy. Has not been largely an event that would result in discipline.
Yep, I agree.
But I like it. I mean, I like the concept of saying to the leader, look, you were not accountable to an important part of your job. Mm-hmm. It doesn't mean we have to fire them over it, but should they be counseled and written up for it? Absolutely.
So this is just one more example of what we've learned from the Twitter experience. We can polish some of these things up, maybe take away a nugget here and there back to our own organizations, right? Maybe we've gotten a few ideas based on how this is all unfolded.
Right. Excellent. Good stuff.
That was fun, Sarah.
That was really fun.
So thanks for joining us today. We hope you learned a few things, and we'll see you next time.
Thank you.